Indian Judiciary, the Supreme Court. Now, the Supreme Court of India is the highest judicial court and the final court of appeal under the Constitution of India, the highest constitutional court with powers of judicial review. Now, Article 124 provides for the establishment and constitution of Supreme Court. Parliament by law determines the number of judges. Now, the judges are appointed by the president and they are appointed by warrant under his seal, hand and seal, which means this function cannot be delegated. Also, the judges hold office until they attain the age of 65 years of age, and they can resign anytime by addressing that resignation to the president. They can also be removed by the parliament and the president, the combined parliament, through a motion. Now, the oath is to be administered by the president itself. And the judges of the Supreme Court shall not plead in any court or authority within the territory of India. Now, the qualifications of the judges of the Supreme Court is that they have to be a citizen of India and they should have experience as a judge of a high court for 5 years or for two or more such courts, and they can should be an advocate of the high court or two or more such courts in succession. This is for 10 years, and they should be either be a distinguished jurist in the opinion of the president. Now, appointment of judges. The judges of the Supreme Court are appointed by the president. The appointment is based on the collegium system. Now, the collegium system was born in the third judges cases, and it is in practice since 1998. It is used for appointment and transfers of judges in high courts and Supreme Courts. Now, no mention of the collegium either in the original constitution or in successive amendments is there. Also, in the third judge's cases, which is in 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation by of plurality of judges. The CJI should consult a collegium of four senior most judges of Supreme Court, and even if two judges give an adverse opinion, he should not send the recommendation to the government. So it should work in a majority sense. Now, through the 99th Constitutional Amendment Act of 2014, the National Judicial Commission Act, that is NJAC, was established to replace the collegium system for the appointment of judges. However, the Supreme Court upheld the collegium system and struck down the NJAC as unconstitutional on the grounds that involvement of political executive in judicial appointment was against the principle of basic structure, that is the independence of judiciary, which forms the part of basic structure. Now, the removal of judges is to happen by an order of the president. However, this removal motion needs to be passed in both the houses of the parliament by a special majority in the same session, which is to say a collective will of the parliament. Now, the motion is to be on the ground of proven misbehavior or incapacity. Now, the Parliament may provide by law to regulate the procedure for the presentation and address and investigation of such charges. Now, the Judges Inquiry Act of 1968 regulates the procedure regulating the removal of the judges of the Supreme Court by process of impeachment. The impeachment word as such is not used in the Constitution, but it is similar to the impeachment process of the president. Now, no judge of the Supreme Court has been impeached so far. Impeachment motion of Justice V. Ramaswamy 1991-93 and Justice Deepak Mishra 1917-18 was defeated in the parliament. Now, the salaries of Supreme Court of India is provided for in the Article 125, and it is to be determined by an act of parliament, and it shall not be varied to his disadvantage, and it includes salaries, allowances and pensions, etc. Now, the president may appoint acting CJI in case of vacancy or absence of CJI. This is provided for in Article 126. Now, for appointment of ad hoc judges is provided for in Article 127. In absence of quorum, CJI with previous consent of President and after consultation with Chief Justice of High Court concerned may appoint Judge of High Court as ad hoc judges of Supreme Court. So High Court judges can be elevated as ad hoc judges of Supreme Court, and this has to happen with the consultation of the Chief Justice of the High Court concerned. Now, they shall enjoy the powers and privileges of judges of Supreme Court. Now, Supreme Court to be a court of record is provided for in Article 129. Now, court whose proceedings are recorded and available as evidence of fact. It means court of record. So, their proceedings are recorded and they are available as evidence of the fact. Now, Article 125, High Court of the states shall also be court of record. This is provided for in Article 125, and Article 129 provides for court of record. Now, they also have the power to punish for contempt of the court. Also, the seat of Supreme Court, which is given in Article 130, is to be in Delhi or any other place as decided by the CGI with approval of the President. Now, original jurisdiction of the Supreme Court, which is provided for in Article 131, is between any cases regarding Government of India and the state or states. They can be between the Government of India and states versus states or any other states. They can be between states and states. So basically, they are dealing with the federal structure. Any dispute relating to the federal structure shall be under the original jurisdiction of Supreme Court. Now, appellate jurisdiction of Supreme Courts come under the Article 132, 133, 134 and 134A. Now, appeal on civil, criminal or other proceedings to Supreme Court, provided HC High Court grants a certificate of leave, is provided for in 134A. So, provided it involves a substantial question of law relating to interpretation of the Constitution. Now, appellate jurisdiction of Supreme Court in civil matters is provided for in Article 133. Now, cases should involve substantial question of general importance if, in the opinion of High Court, the Supreme Court should decide the matter. Now, the certificate is to be issued by the High Court under 134A. Appeal in cases of criminal matter, sentence is death. It is a matter of right. Like in criminal cases, if the sentence is of death, it is a matter of right. Otherwise, it is a matter of discretion of the Supreme Court. Now, the case has to be certified by the High Court under Article 134A. Now, special leave jurisdiction is provided for 136A. Now, Supreme Court has the discretion to grant special leave to appeal from any judgment, decree or order. This is a special provision to provide for appellate jurisdiction. Now, power to review its own order and decisions. Now, Article 137 provides that Supreme Court has the power to review its own orders and judgments. Now, the subjects are rules made by Supreme Court under Article 145 and law made by the Parliament. Moving on, Article 139 provides for the power to issue any writ apart from fundamental rights by a law of Parliament. Now, 141 provides for law declared by Supreme Court to be binding on all courts. Also, 142 gives extraordinary power to Supreme Court. Supreme Court can pass any order, decree to do complete justice on any matter pending before it. Now, Article 143 gives power of the President to it is the power of the President to consult Supreme Court. Now, it is in advisory jurisdiction of the Supreme Court. Now, Article 145 provides for the rule-making power of the Supreme Court. Subject to law of Parliament, Supreme Court to make rules with approval of President, regulating general practice and procedure in the House. Now, 5 judges to decide any substantial question of law under Article 143. So, 5 judges to constitute a constitutional bench. This is provided for in Article 145. Article 146 provides for officers and servants and the expense of Supreme Court. Now, CGI may appoint officers and servants of the Supreme Court or other such judges or officers as the court may decide. So, there is a lot of discretion over here. Now, conditions of service shall be made by CGI subject to law made by Parliament. Now, salaries, allowances, pensions or leave require the approval of the President. Now, administrative expenses of the court, salaries, allowances, pensions, etc. are to be charged on the Consolidated Fund of India. Moving on to the High Courts, Article 214 provides that there shall be High Courts for each state. Every high court shall be a court of record and shall have the power to punish for its contempt under Article 215. Now, every high court consists of the Chief Justice and other such judges as the President may from time to time deem it necessary to appoint. Now, appointment and conditions of service of a judge of High Court, which is provided for in Article 217. Every judge of High Court shall be appointed by the President, not the Governor, by warrant under his hand and seal. They shall hold office until the age of 62 years. Point to note is for Supreme Court it is 65, here it is 62. Now, President shall consult the CJI, the Governor, and Chief Justice of the concerned state where the appointment is to be made for the other judges of the High Court. Now, the judges of the High Court to take an oath administered by the Governor, however, they are appointed by the President. Now, the judges may resign any time, and this resignation is to be addressed to the President, which makes sense because he is being appointed by the President. Now, judges may be removed in the manner provided under the Article 124, same as Supreme Court judges. Now, office may be vacated due to appointment to Supreme Court or transfer to other high courts by President. Moreover, qualifications for judges of High Court is that they shall be a citizen of India. They shall at least have 10 years of at least 10 years of judicial office in the territory of India, or they should be an advocate of High Court for at least 10 years or High Courts in succession. Moving on, any question with regards to the age of a High Court judge of a High Court, President's decision is final, taken after consultation with CJI. Now, any permanent judge of High Court shall not plead or act in front of any authority except the Supreme Court or other High Courts. Now, Article 222 provides for the transfer of judges from one High Court to another, and they are to be done by the President with consultation of the CJI. Transfer judges from one High Court to another. Now, Article 223 provides for acting Chief Justice. Now, President may appoint acting Chief Justice if Chief Justice is unable to perform his duties. Moving on to additional or acting judges of High Court. Additional means more work pending cases. Additional judges can be appointed. Not exceeding 2 years, not after attaining 62 years. So these are the exceptions or the conditions which must be abided for providing for an additional judge. Now, acting judge, when any judge is absent, not able to perform his duty, especially acting Chief Justice, acting judges under such circumstances are to be provided for. Now, tenure is not exceeding 2 years and not after attaining 62 years of age. Now, moving on to appointment of retired judges of High Court. By Chief Justice of High Court, with previous consent of President, request retired judges of High Court, other High Courts to act as judge of that High Court. Now, salaries, allowances to be determined by President. Moving on to jurisdiction of High Court. Constitution does not provide for any general jurisdiction of the court under Article 225. However, it says it exists as at the commencement of the Constitution. Now, subject to law made by Parliament and state legislature. This jurisdiction is to be subject to law made by Parliament and the state legislature. So this is important. Moving on to original jurisdiction, there is no original jurisdiction in case of criminal matter. However, original jurisdiction lies in certain civil cases of higher value. Now, appellate jurisdiction is available both in civil and criminal matters. Now, letter patent appeals in the case of High Court of Allahabad, Bombay, Calcutta, Madras, Patna High Courts is available. Now, High Court's power of superintendence, which is given in 227. Every High Court has the power of superintendence over all courts and tribunals throughout the territory in relation in which it exercises jurisdiction. Now, it can issue general rules. It can regulate practicing and proceedings in the courts, prescribes forms in which entries and accounts are to be kept. Now, such rules require previous approval of the governor and should not be in violation of any law. Now, Armed Forces Tribunal does not fall within the jurisdiction of high courts. However, Supreme Court can intervene. Now, writ jurisdiction under 226, writ jurisdiction throughout the territory in relation to which it exercises jurisdiction. They are available not only for the violation of fundamental rights, but they are available for other purposes as well. Example, legal rights. Now, transfer of cases to High Court under Article 228. The High Court can transfer cases pending before a subordinate court to itself if it involves a substantial question of law as to interpretation of the Constitution. Now, extension of the jurisdiction of high courts, which is given under Article 230. Now, Parliament may by law include or exclude jurisdiction of high court to any union territory. Now, establishment of common high court for two or more states under Article 231. The Parliament may by law establish common high courts for two or more states. That'll be it.